mention?
Yes.
With the question of the other side, I beg to mention item.
You're not audible, Mr.
Am I audible now, Lordship? With the consent of the other side, I beg to mention item 10 of today's daily list.
Item 10.
Lordship, similar matter is already pending before the Manipur High Court.
Okay. With the other side.
So hence, my lord, from Mr. N. Mujika, the consent has already been taken from him.
Item 10. Yes, for how long you want it? For how long you want it?
My lord, 2 months.
2 months. You do not adjourn.
My lord,
You do not adjourn matter for such a
4
long
weeks.
time.
My lord, in 4 weeks since situation in Manipur is not that well now, so the court is not sitting that regularly. The matter is fixed on 21st September next.
Okay. The prayer made by both the parties. List is matter after 4 weeks. We will not say it is, see any matter is pending before morning, or that will not be a bar for this court to take up. After 4 weeks. Yes.
My lord.
Your Lordship, I beg to mention item 15. Your Lordship, this matter cannot be taken by this bench.
This cannot be taken up by this.
No, Your Lordship.
Yes, list this matter before any other bench without me.
Obliged, Your Lordship.
Obliged.
Your Lordship, I'd like to mention item number 8 and 9. It's a connected matter.
My lord, this is, if your Lordship remember, this is a matter pertaining to this cantonment area whereby lease amount has been enhanced by the central government, by the Ministry of Defence. My lord, what had happened in between? There has been a move from the Ministry of Defence for exclusion of the civil area, my lord. So we are waiting for the notification by the Ministry of Defence also.
Your area falls in that area, the area which is to be.
My lord. So that statement has been given before the Parliament also, my lord. We are just waiting by the Ministry of Defence, my lord. We are waiting for the notification. Formal notification, my lord.
So once that notification comes, then
This
will not survive.
Shillong Municipal Board, my lord. That will fall under
So the order under challenge will not survive anymore.
My lord. Maybe the
So
entire
anyway, now
infrastructure for the realization of the least amount, that will change, my lord.
but then until and unless there is something concrete, can it be? Will it be proper for this court to record that? And
My lord, what I'm saying is that the matter can be taken up after.
there is also, I think, you mention is made on behalf of Mr. Mohanto.
My lord, on his. Well, a similar matter also is pending before another court, my lord. Just thank you, my lord. Just Lordship, this order. Same matter, my lord.
Same matter.
Similar matter.
So why some matters are there, some are
I
here?
think maybe the year, my lord. This was filed 2019, and this case has been filed subsequently, my lord.
So we can record the same.
My lord can record the same.
That will go as your submission.
My lord. Once the notification is officially out, my lord, then I'll place it before this court, my lord. And the entire area will be before the Shillong jurisdiction, before the Shillong Municipal Board, my lord.
Okay. Mr. L. Karim, Lord and Counsel for the petitioner, submits that process for the exclusion of excesses of civil areas from the limits of the Shillong Cantonment Board is under progress. The submission advanced by the Learned Counsel has not been disputed by the Mr. Shulai. You have a part here.
In fact, Your Lordship, we have
not disputed by the Learned Counsel for the respondents. Accordingly, list this matter after 4 weeks.
4 weeks.
Item number 8
and 9.
8 and 9. If anything comes,
you are also there in 9 also.
Yes, Malad. If anything comes up, any notification comes up before that, Malad, then we'll mention it before the court.
Yes.
Obliged.
Obliged.
Please, Your Lordship.
Yes.
I'd like to mention item 14. It's Assam Rifle matter, Your Lordship.
Yes.
Mr. Chanda is indisposed today. So.
When do you want it? No objection, Mr. Devnath. When do you want it?
After 2 weeks, Your Lordship.
You are also there. You can take up.
I'll be.
Now, if you appear and if you made a submission saying that Mr. Chanda is indisposed,
Lordship.
will it be ground for adjourning you since you are advocate on record? Okay, just a submission has been made on behalf of Mr. M. Chanda, learned counsel for the petitioner, that Mr. Chanda is indisposed. The learned counsel for the petitioner prays for adjournment of the matter on that ground. Mr. R. Devnath appear for the respondent. Has no objection. List this matter after
2 weeks.
2 weeks.
Obliged.
May I please, Your Lordship? I'd like to mention item number 5. I pray for 3 weeks' time. We are not ready with the matter, Your Lordship, due to personal difficulty.
Can it be ground for adjournment? You are not ready. This is a 2018 matter.
Yes, Your Lordship.
What is the matter about?
It's a service matter, Your Lordship. Service matter.
No
No
objection.
objection, Your Lordship. Let it come after 2 weeks, Your Lordship.
These are all, see, old matters. Give your name, please.
And
You are appearing.
Yes, Your
Your
Lordship.
name is there. Learned counsel of the petitioner. Please for grant of 2 weeks' time. Stop. MS Jed non-plenary appearing for the state counsel respondent. State respondent has no objection. Prayer allowed. List after 2 weeks.
Obliged, Your Lordship.
Main list, item number 1.
Yes. Yes. Yes, Mr.
Your Lordship, this is a matter whereby the petitioners are challenging the order passed by the Meghalaya Lokayukta.
Yes.
And the consequent thereafter initiation of criminal prosecution against the petitioners in special court of law. This order is being challenged, Your Lordship, basically on 2 grounds.
Where is the order?
First-
Where is the order? Where is the order? Let us first see the order.
Your Lordship will find Annexure P1, that is the order dated 28th of July 2023. This is at, Your Lordship will find it at page 30.
Yes, yes.
It says that case record put up today along with investigation report submitted by Shri Anil Sangma MPS retired, member of the inquiry wing Meghalaya Lokayukta. The following public servants / respondents are charge sheeted under section 12 and 13
No,
of
this
the
is
Prevention-
only a mere forwarding.
Yes, it is
You are
not
not
a mere forward.
Yes.
Yes, and Your Lordship, I am petitioner number, Your Lordship will find my name at serial number 10, Sanjay Sangma contractor, and then 11 Dolritz D. Sangma contractor. And thereafter, the Lokayukta orders that the Director of Prosecution will forward the case records in the original to the Public Prosecutor West Karo Hills, Surah, to institute prosecution in a special court of West Karo Hills, Surah, to initiate prosecution in a special court of West Karo Hills, Surah.
Prevention of Corruption Act.
Prevention of Corruption Act.
Yes.
And your Lordship sees in this order itself two glaring facts. One, I am a contractor. At serial number 10 and 11, I am a contractor, and it is my submission that Lokayukta has no jurisdiction over contractors. Lokayukta, your Lordship knows, is a body which has been primarily enacted for checking corruption by public functionaries, and it has no jurisdiction over the contractors.
Yes.
This is one of my grounds as far as jurisdiction is concerned to challenge this order. And secondly, your Lordship sees one more glaring fact from this page itself.
See, Lokayukta here has not exercised any jurisdiction so far as you are concerned. This is only mere forwarding of the charge sheet. Now, in a prevention, even in a Prevention of Corruption Act, say supposing if any private individual is charge sheeted along with some public servant, do you want to say that private individual cannot be tried by a special court?
Your Lordship, under the Meghalaya Lokayukta Act, in the facts of this case, it is not possible, because if your Lordship sees that this order has been passed pursuant to the complaint filed by the respondent number 2. And
now, just a minute. Was there any order to investigate against you? Was there any particular order?
Yes, your Lordship.
Where is that order? That is not under challenge here.
Your Lordship may see. The order, the complaint first, and then I will take. Your Lordship will see at page number P9, which is at 86. This is the complaint on the basis of which that order has been passed. And your Lordship will see that.
No, in that complaint you are not named.
I am named, your Lordship. In this complaint, I am named. Your Lordship sees at page 86 that the respondents, your Lordship sees the respondent number 2 and respondent number 3.
Okay, yes. So you all are private individual.
I am a private individual. And your Lordship sees at
then
paragraph
where is the initial order by which investigation was directed against you?
Your Lordship sees the order dated Lokayukta at page 92A. Your Lordship sees the notice has been issued to all parties.
Yes.
And this is the order initiating the process in this matter. And then your Lordship will finally see the notice issued to me by the inquiry officer at page 96.
Yes, but then where is the order by which inquiry was directed?
Your Lordship, the orders, because I have not been a part of the proceedings in this matter.
No,
so
but
I have received.
You are challenging this order of forwarding, but then where is that? You see, in absence of any challenge to the main order, how can this order be interfered?
Your Lordship will see at page 96, because what I am saying is that the entire proceedings is jurisdictionless.
So in such a case, you should have challenged this entire complaint against you. There is no challenge.
Your Lordship, I am praying for the quashing of the entire proceedings also, Your Lordship. So Your Lordship sees 96, and 96 is is revealing in a sense. 96 is issued to me, Sanjay Sangma, and then it says, in exercise of powers under section 22, 14(1)(d) of the Lokayukta Act 2013. I do hereby inform you that in connection with the above noted case filed by so and so, that there is a reasonable ground to inquire from you for ascertaining the facts and circumstances of the instant case. Therefore, in this regard, you are required to appear before so and so.
Yes.
So, and if your lordship just sees for a moment section 14, because the notice has been issued to me under section 14, section
Yes.
14 of the Lokayukta Act.
Where is that?
Your lordship can also find it at page 45 of my petition.
45.
Just prior to section 14, your lordship, if your lordship permits me, I'll just take your lordship to the preamble of this act. The preamble your lordship sees at page 35.
Yes.
An act to provide for the establishment of a body of Lokayukta for the state of Meghalaya to inquire into allegations of corruption against certain public functionaries. And I impress upon this fact that, your lordship, the act has been created for checking corruption against public functionaries. Then your lordship sees section 2N of this act at page 37.
Yes.
It says, your lordship, public servant means a person referred to in clause A to H of subsection 1 of section 14, but does not include a public servant in respect of whom jurisdiction is exercisable by any courts. So the section 2.1 is basically directing us towards section 14, and now finally your lordship sees section 14 at page 45.
H 44.
Yes, yes. I apologize, Your Lordship. The marginal note itself is jurisdiction of Lokayukta to include chief minister, ministers, member of legislature, and officers and employees of the state government. And now your lordship sees this provision. It says, subject to the other provisions of this act, the Lokayukta shall inquire or cause an inquiry to be conducted into any matter involving or arising from or connected with any allegation of corruption made in a complaint in respect of the following, namely, one, the first one, A, your lordship, any person who is or has been a chief minister and deputy chief minister, not applicable. B, any person who is or has been a speaker or deputy speaker, not applicable. C, any person who is or has been minister, not
Whether
applicable.
all the person named in the complaint are private individuals?
Your lordship, the petitioners are private individuals.
No, apart from them, others, they are a public servant.
It is by case that even they are not public servants, because they are officials of GHADC, that is Garo Hills Autonomous District.
So they will not be public servant.
They will not be public servant under this provision. Your lordship sees this provision. This provision, again, your lordship sees it from both perspectives, from the perspective of the petitioners and also from the perspective of officials of GHADC. They will not fall under A, that is in respect of chief minister. They will not fall under B.
Yes, yes, understood, yes. Come to the relevant part, where to say.
So, your lordship, if I see from A to H, it talks about...
What about F?
Yes. I'm obliged, your lordship. It says that any person who is or has been a chairperson or member or officer or employee in any board, in any body or board or corporation or authority or company or society or trust or autonomous body or district council by whatever name called. And now, your lordship, here is the important point. It says that established by an act of parliament or of a state legislature or wholly or partially financed by the state government or controlled by it. So the autonomous district councils are not established by any act of the state. Neither they are established by any act of the parliament. So they are financially autonomous. So it is my humble submission that they will not even fall under F.
So what else?
And there are
what other ground you can?
Yes. So, Your Lordship, my first submission is that I am a private person. I am completely outside the jurisdiction of Meghalaya Lokayukta. Secondly, even otherwise, my submission is that officials of GHADC are also not within the purview of the Lokayukta, and they are not public servants under the Act. My third submission, Your Lordship, here would be that if Your Lordship sees what has been the consistent practice of Meghalaya Lokayukta, they have consistently passed orders that private contractors are outside their purview. In this regard, Your Lordship sees page 84. Your Lordship, page 84 is an order passed by the Meghalaya Lokayukta itself, and it is an order dated 26th of February 2021. And Your Lordship sees the relevant part over the page at 85, the last paragraph. It says that, Your Lordship, due to lack of jurisdiction over non-government servants, persons, Your Lordship, it is the last second paragraph.
Yes,
and it says, due to lack of jurisdiction over non-government servant, persons like contractors as mentioned earlier and other legal hurdles in great interest of public and for doing justice, so and so is directed. So it is an admitted fact that they do not have jurisdiction over contractors. And their directions, so far as these directions are concerned, I may just bring to the notice of this court that even these directions are challenged by the state itself, saying that if you do not have jurisdiction over private persons, you do not also have the jurisdiction to pass any consequent directions.
What is the outcome of that challenge?
Your Lordship, that is pending as writ petition 363 of 2021. That is pending challenge.
This is before pending before some other court.
Pending before, I think Your Lordship, it is pending before this court only, and it is pending before, I believe, Honorable Mr. Justice Dingno.
Oh, yes. So it is pending before some other bench.
Yes, but the admitted fact is that the challenge is to the extent of further directions. The challenge is not on the point whether they have jurisdiction or not.
Yes, other side. What you would say?
So far, state is concerned, Lordship, the role is very limited because this is complaint initially filed before the Lokayukta. On the basis of the complaint, Your Lordship, Lokayukta has taken.
So you are not interested in pursuing that case instituted before the Special Court, Prevention of Corruption Act?
Lordship, for that I'll have to.
The state is not directly. You are for? Yes. What about the Mr. Sulai says that state doesn't have much say here.
You can come here.
You do one thing, Mr.
Lordship.
We'll issue notice, you file your affidavit.
Lordship, but
will not pass any interim order.
Yes, Lordship. But here, Lordship, may I just submit this similar cases, Your Lordship, the same nature of cases whereby the division bench have already set aside in course the same nature. Yes, Lordship. This is the order, Your Lordship. And against this order, they have went to the Supreme Court, and the Supreme Court also have dismissed their case.
Is it the same contention?
Same contention, same person.
Is it?
There is a strong order, Your Lordship.
State is not a party to here.
And state was a party.
In that case, they have challenged the amendment.
Your Lordship, I believe that is some other matter where.
Yes, Mr. Please, Mr.
Lordship,
hold it, please.
May I just submit, Your Lordship?
I apologize.
Their challenging mainly is not only the act. Lordship, if you read the order, they were challenging even that impugn order whereby the Lokayukta has framed a charge against all these people, including Sanjay. Sanjay Sangma, before he was.
Do one thing, you file your reply. You file your reply. And we'll take this matter after you file the reply.
And yes, Lordship. And I just want to say, my learned friend was saying that page 44, what he's saying that Sanjay Sangma is not under public servant. The act, the section 14 E, that is very clear why he is not a public servant, how he is not a public servant. Lordship, as per the Prevention of Corruption Act, the section 41, that page 44 E, Lordship, page 44, there is a 44 sub 1 A, B, C, D, E. The E, it says that all officers and employees of the state from amongst the public servant defined in sub clause 1 and 2 of the clause C of section 2 of Prevention Corruption Act. What is the section 2 of the Corruption Act? It's very clearly stated in the sub clause 1, 2 B of section. This is the subsection C. It says in the Prevention of Corruption Act, Lordship. I have another book, but I didn't bring. But here, may I read it, Your Lordship? Here it says that any person in service or
which one you were reading?
Lordship, this I have this.
No, section. What section?
Prevention of Corruption Act, page.
Prevention of Corruption.
Corruption Act, section 2. This one.
Yes, section 2.
Section 2, Lordship.
Yes.
The C, where the section E of that, where the locator, they are referring to this one only. C, then 1, that's C1, Lordship. Any person in service or pay of the government or remunerated by the government by fees or commission for the performance of any public duty. Now, Lordship, this scheme, actually there was 100 crores and 0.75.
No, first you confine to a public servant.
Lordship, I will come to
Yes.
I will come to that.
Okay.
It was sanctioned by the government, central government.
Yes.
For amount 118 project. And that out of that 118 project, the central government of India has sanctioned that money for development of the tribal areas. And out of this project, 6 lakh was allotted for particularly to this Sanjay Sangma. Sanjay Sangma is that time he was a contractor, and it is in the from the prima facie report is that there was a preliminary inquiry. From the preliminary inquiry, it was found that he was found prima facie. Period for completion of the project was for 2 years. He has never completed the project.
Come to the definition.
Lordship, I'm coming to the definition.
Just because
Lordship. What I'm saying,
the central government doesn't mean that he was getting salary.
No. It says that any person in service or pay of the government or remunerated by the government by fee or commission for the performance of any public duty.
So he was not supposed to get any communication or remuneration or pay from the amount sanctioned.
Lordship. No, for the purpose of public duty means like this is particularly for the contract that money has been sanctioned for. That money was for development.
You file your reply. Will issue notice. You issue notice.
Lordship, if I may make one submission.
Yes.
Your Lordship may kindly have page 127A of the petition. Your Lordship, 127A.
Yes, 1 minute. Yes.
Your Lordship, 127A is a summons issued to me by the special court. So the process is initiated, and it is my submission that the entire proceedings have no jurisdiction. So I am praying if some...
No, that is, there are two aspects. Your submission with regard to the fact that the employees of district council will not come under purview of public servant. That is one part.
Right. Yes, Your Lordship.
And the second part is that there is no challenge to the main order by which an inquiry was ordered against you. Now you have come only when you found that your name has figured in the investigation report or in the charge. Now, probably the Lokayukta has never not exercised any direct jurisdiction over it. But then what happens in a case of correction? Private persons may be involved. Lokayukta has not passed any direction against you.
He's the main respondent in the Lokayukta also, Lordship. If I come to page 86.
They have never sought for quashing of the complaint. Was it made?
Never. Only after filing. This is the first.
No stay at this stage, Mr.
Your Lordship, I have been praying for one indulgence. That if Your Lordship may fix this matter prior to 31st of August 20.
It's gone. 31st of August is gone already.
I'm sorry. Your Lordship, it is.
And another, Lordship is.
See, this court basically would like to see what reply comes from the other side. They should also get time to prepare and all. You have raised certain queries, let them answer it.
Your Lordship,
Once the reply comes, then we may take up the matter for consideration of interim prayer.
Your Lordship,
see, your trial will not be concluded.
Another aspect,
your trial will not be concluded in one day.
Lordship.
If at all there is a case of interference.
In this order, there was indication that any trial,
Wait. When the court is communicating with the other side counsel, please do not talk to me. You see, if court finds that at all you have a case, that the criminal stage, whatever stage it remains, criminal case, whatever stage it remains, would be nothing. It would not mean anything. The proceeding will go. Will issue
Lordship. Finally reply.
Your Lordship may fix a returnable date.
Yes. We'll be getting date after 2 weeks. How long will it take to file a reply?
3 weeks, Lordship, because it is so many.
But then you make sure you file it.
I file
it. The question of law will not keep it pending.
Lordship. Otherwise, in other cases, they used
don't
to make the
Lokayukta
also as a party.
State is not in a mood to support it.
Yes, Lordship. because the private respondent now is elected MLA. So most probably they don't want to support.
Pandey, you are Mr. Pandey? Yes, Mr.
Yes.
Mr. Pandey, learned counsel for the petitioner. Issue notice. Returnable in 3 weeks. How many respondents are there? Respondent number 1. Mr. Adi Shulai, learned AG, along with Ms. Jadi completely appears for the respondent number 1. Mr. P.T. Sangma, you have power. Bhagatnama, you have.
Lordship, I have.
Yes.
We have already submitted today
morning.
morning.
Something like that.
Today morning, Lordship. We have submitted.
Yes.
We have filed it. It is there on
P.T.
record.
Sangma, learned counsel for learned counsel enters appearance for respondent number
5.
For on behalf of respondent number 2.
Lordship.
As such, no formal notice is called for. This matter after 3 weeks. In the meanwhile,
Lordship, one thing, and in all the cases, Your Lordship, whatever order of the Lokayukta is challenged, we have been practically they have been whoever challenged the order of the Lokayukta, they have been making a party to the Lokayukta. But this is the only first time they are not making party. But I'm saying because
that may not be required.
Why it's not required? Because they are the main because their order is a quasi judiciary.
So this entire order has been passed on your complaint. Okay. Now that is what we'll first justify. We'll see if required, then we'll see.
Lordship.
And let us see what happens. Lokayukta come by themselves, and we'll see.
Lordship.
Is this matter after this? Yes. What is it? Same.
Much respect.
Just call for item number 2. Yes. Just give me the item number.
Continue.
Yes. Here also you are private individual.
My lord, here we are all all the petitioners are GHTC officers and staff. And out of the 10 petitioners, my lord, only the petitioner number 10 was a party to the Lokayukta proceedings. His name was mentioned in the complaint. Apart from that, the petitioner numbers 1 to 9 were neither aware about the Lokayukta inquiry, and after that, it is only during the period of inquiry that they got to know.
But then you see, you come to your petition. See paragraph number 1 and all. It doesn't say that there are many petitioners.
I am about to clarify that aspect, my lord. The petitioner number 1 is the deputy CEM, and
see your petition. See your senior environment in paragraph number 1 and paragraph number 2. Now it seems like petition filed only by one person.
That's what, my lord. I'm just about to clarify that aspect. The other officers were initially not about to file the petition, but due to oversight, we could not.
You should have corrected. You should have.
Additional affidavit, my lord.
Anyway,
We'll
the same
file
order.
additional affidavit.
Same order in the other case.
Lordship.
My lord.
Take care of that part. Whether the employees of GHDC would be.
Yes, my lord. I'll file one additional affidavit, my lord, bringing on record the status of all the petitioners.
This one, I have not received any copy of this because
Second petition.
no.
My lord, the copy shall be provided.
Yes, yes. Okay. Please, provide it to Mr. P.T. Sangma.
Yes, my lord.
Yes.
By the itself, my lord.
Lordship.
What about this order, Mr.? Keep it with you when you file your reply. Bring it into the.
My lord, there is one small prayer, my lord.
Yes.
My lord, we approached the Lokayukta for a certified copy of the entire case record. But we could not get it because the records have been sent to the special court to the original record has been sent.
They have to get it from
Only
special
the
court.
Lokayukta portion, if that could be called, my lord.
No.
Only the Lokayukta portion that may
You see, otherwise, the order is there, isn't it? The copy of the order is there, isn't
my
it?
lord, the inquiry orders, etc., the initial orders are not here, my lord. We could not get it from the.
Anyway, we'll see it in the returnable date.
Lordship.
Right now, court is not.
Lordship.
Hearing item number 4.
This also. Inside this.
Yes. But I am appealing for the respondents, my lord. This is a very old matter, my lord. Though I went through the file this morning, my lord, Mr. Jha can start if I can conclude today, or I can maybe allowed to conclude.
The thing is
tomorrow.
that this court doesn't have a very sharp brain, doesn't remember everything, forget. This court,
well, I'll try to reply today itself, my lord. If on some point I'm stuck, my lord, I'll reply tomorrow, my lord. May not be necessary, my lord, only as a precaution I'm submitting.
Yes, Mr. Jha.
My lord.
Let us begin. Let us see how much you can.
This was heard by my lord. This is he went on leave, absent without leave. For
who is employed
BSF,
in which
BSF, my lord.
Yes.
Border Security Force. The absence was of 305 days, your lordship.
The petitioner was working as
a constable, my lord.
Constable GD.
My lord.
Ashwini Patti. Okay. And then he took leave.
My lord. He took leave and
Yes.
admitted absence of
Overstayed the leave.
Overstayed the leave, and he has communicated with the kid on medical ground. The impugned order is at page 37, my lord.
JP means journey period.
Journey period.
You were overstayed for more than a year.
305.
305 days.
12 or 5. Year. Almost a year. Yes, very severe for a man belonging to a force.
My lord, that's a but the question is that whether that sufficient cause was there or not. The question that I myself as a willful I have, or was there any communication? It says that, my lord, what is the charge? Without sufficient cause, the allegation, they have not denied, my lord, that I have been sending the medicals from the place of my leave. They have not sufficiently, whether that my willful absence, if I am willfully absent, my lord, I am entitled for the misconduct.
Now, sufficiency and insufficiency, to what extent this court can go into?
My lord, it is the impugned order, the manner in which it is the authority, my lord.
Probably, you see, you will be trying to take court into the merits of the decision and all, the sufficiency and insufficiency of the reasoning. I don't think this would be the court will have any power to do that under when it exercises power under judicial review?
Judicial review.
It is, we are mostly confined with the process, is it, the decision-making process.
My lord, that is the decision-making process. My lord, why I am hampering on the allegation under section 19, for which
where is the allegation? Where is that? Take me to the allegation and all. See,
no,
where is that?
They have not served any tentative charge sheet or nothing. It's directly a impugned order, which says, my lord, under accused number such and such, BSF Act under section 19B, my lord.
Yes. What does it say? 19B.
My lord, 19.
Now, shall on conviction by a security force court shall liable to suffer imprisonment for a time which maximum 3 years and so on. That's that person. Okay. Now, was it your case that you are convicted by a security force court?
Yes, it is admitted that I have been.
Is it something different than the departmental proceedings?
No, my lord. In BSF or a paramilitary force, what is there, my lord? Inquiry is made, and there are 3 types of courts, my lord. PT security force court, then summary security force court, and my lord, it's a general security force court.
So they can award punishment of dismissal from service. They can. There is no dispute.
They have the power is there, my lord. But the reason for which, whether my absence was willful, or it was I have a sufficient cause which has restrained me to join my duties, my lord. That reasonableness the department ought to have taken into consideration. They would have during that court proceeding, my lord. They have not. My lord, dismissal is also a highest punishment, my lord. It's a highest punishment, my lord.
If you take into consideration the period of absence, it's okay. It is proportionate. Only thing is that whether your explanation,
my lord, that
is, I don't know whether explanation whether that would be which way it should be appreciated is up to them. But then whether that was taken into consideration or not, that is what is to be seen.
The affidavit is totally silent, my lord. Affidavit is totally silent. My lord, no show cause notice was given to the petitioner.
Now, in a security force court, in a proceeding before security force court,
my lord,
how a delinquent official takes his defense? What is the procedure?
The procedure, my lord, it's a friend of the accused, like a
that is so far as the proceeding. But then, was there any system? Is there any system of filing a show cause like what normally happen in departmental proceeding, or is there?
They should, if I have been alleged with any offence, my lord.
Now, say supposing there is an allegation against you,
my lord,
that you overstayed leave. Okay, and they basically seek to do a proceeding against you. In such a case, is it required upon them to seek a written explanation from you before they decide to take up the matter in the Security Force Court?
There are two ways, my lord. As far as the procedure is concerned, my lord, first they had to initiate a court of inquiry, my lord.
This is a kind court of inquiry, something fact finding.
My lord, in the fact finding. After that court of inquiry, my lord, is complete, my lord.
What role you have in court of inquiry?
Court of inquiry, my presence should be there, my lord. If it is not Prithpal Singh Sethi case,
So
my lord,
without court of inquiry, no proceeding can be taken.
cannot
Security
be,
Force Court.
cannot be.
Where is the law?
My lord, that's
Is it correct, Mr. Mojika?
after the court of inquiry, the hearing of charge.
There has to be a court of inquiry, then there only. Is it correct? That's only that much.
My lord, this is a three-stage process, my lord, in the security forces. Whenever there is some complaint against somebody, my lord, to ascertain whether such things actually happened or not, there is a court of inquiry, my lord. Some statements are recorded of the concerned person, and on the basis of that, if there is a prima facie material that something is there, then the court of inquiry is placed before the higher authority, my lord. And then if higher authority is satisfied, then the second stage comes, that is called record of evidence, my lord. In normal criminal trial,
These are all mandatory.
These are all mandatory, my lord.
Before a matter goes to Security Force,
my lord. So record of evidence is recorded, my lord, and that is again placed before the higher authority. If higher authority is satisfied that yes, prima facie case is made out, then the matter is sent for trial before the Security Force Court, my lord. The only requirement is that, my lord, some record of evidence should be, copy of that should be supplied to him, which has duly been done here, my lord. And in fact, he pleaded guilty before the Security Force Court, my lord, that he was absent for 305 days.
So procedures were followed.
My lord, the procedure, my lord, after the court.
In our case, full procedure was followed, my lord. All the rules were followed. You can point out what was not followed. I can answer to that.
Yes, yes. So let us see how these three stages were followed, or what is your case on? Just tell us, Mr. Jha, that what are the points?
My lord, I am challenging this impugned order, my lord. The non-following of the procedure, my lord.
Yes, what are the procedures and what have not been followed?
My lord, the procedures is that it is after the court of inquiry, hearing of charge by the commandant should be there, my lord.
Where is that provided?
My lord, that is
no.
Section.
According to you, what are the stages? Just tell us. See, this is a court where you have to explain from going to the basic of the road. Come to rule 45.
Man, just
hearing of the charge against an enrolled person.
Man.
The charge against be heard. Charge shall be heard by the commandant of the following.
By the commandant, my lord.
This speaks about the manner.
My lord. It has to be
now,
heard.
Before the charge,
my lord.
What are the procedure to be followed?
Before the charge, my lord, the court of inquiry should have been.
So was there in court of inquiry?
Court of inquiry was neither annexed in the affidavit nor provided to the.
You must be knowing it. Whether
no,
they annexed or not.
No.
So your contention is that there is no court of inquiry.
No court of inquiry.
Now you have to make submission that way. You see, if you want to say, you just cannot shift the ball. You have come to the court.
My lord.
At least you have to assert the things which you want to raise. You see, like without your assertion, how we will tell them to reply? Now, if you say there is no court of inquiry, then we will ask them why there is no court of inquiry. You say there is no court of inquiry and there is no finding recorded.
My lord.
Are you sure about that contention?
Yes, my lord.
Then after this court of inquiry, who frames the charge?
That is the commandant, my lord.
Hearing of the charge.
Hearing of the charge.
It means charge comes before commandant hears it.
Yes, my lord. Before the command, after the court of inquiry, my lord, the court of inquiry, either the commandant hear the charge by himself or on the basis of court of inquiry.
Where is the provision of court of inquiry?
Court of inquiry, my lord, rule.
Where it is mandated, the court of inquiry has to be done.
My lord, I will. दूसरा वाला किताब का it's
I think you go prepare it and come back tomorrow, Mr.
PSF Act में अलग है procedure is that release of hearing. That is one.
We'll take it up some other day, Mr. It seems you are not prepared. Mr. Mojika. Please come prepared. The points you make it precise, brief and precise. You have to argue on the point of law. If you fail to point out the provisions of law, then it becomes difficult.
But it appears that the only case made out by them is that during the court of inquiry, he could not participate, my lord. My lord, the very essence of court of inquiry in case of absence, my lord, that he is not available. That is why the inquiry is conducted, my lord.
So it was not that the department prevented him from taking part.
He is not available, my lord, and that is the circumstance that he is absent.
In spite of the fact that he was made known that court of inquiry is going on,
my lord,
he was aware of that. My lord, was he notified?
My lord, what happens, my lord? This is a normal routine, my lord. Soldiers, when they go back, my lord, go home, they don't want to come back, my lord, or they come back after 6 months, 3 months, 1 year, my lord. So now, what happens, my lord? If such thing happens on the due date of return, he does not report, my lord.
They wait for 1 week's time, my lord, and then they issue a notice to him that you are absent, you are overstaying your leave, please join. Or if there is a genuine reason for that, kindly intimate it. My lord, being a soldier, it is his duty also that he wants an extension of leave. My lord.
Is there a requirement that the notice is required to be served?
My lord.
It is not enough that it is issued.
My lord, what we issue is, my lord, that is called apprehension roll, my lord. It is in terms of the rules. That is addressed to the superintendent of police of his village or town, my lord.
Where he resides.
My lord, and the superintendent of police is informed that please go and look for him, because normally what happens, my lord, many times they go home, they are armed also, my lord, and there's some other property of VSF are interested to them, my lord. So that is not a normal, like a civilian employee, he overstays leave, that is one thing, my lord, but an armed person or maybe he's traveling with arms, he overstays, that is a matter of greater concern, my lord. So in this case, my lord, apprehension roll was issued to the SP. He says that he is not available. Then we issued 3 letters, registered letters to him that please come and report. If you don't report, then we'll take action against him. He does not report, my lord. When we moved to second stage, my lord, that is recording of evidence, when that notice was issued to him, then he comes and joins, my lord. Knowing very well that now this action will be taken against him.
There is just withdrawal of proceedings after his joining, definitely, isn't it? So he was
Second
well aware.
stage,
He was well aware of.
He participated also, my lord.
As far as the recording of evidence, my lord, that is the recording of evidence by whom, my lord? Here I say that the commandant has not heard its violation of 45B, rule 45B. Hearing of charge has to be heard by the commandant, and before that a tentative charge sheet should have been given to the petitioner, my lord. And thereafter the matter goes for why the 2 stages, my lord? First, after the court of inquiry, the authority has to apply the mind, my lord, whether it is a fit case to be dealt there also, or it has to be sent to the security force court, my lord. And even after recording of evidence, it's like, my lord, the same, and then again it is sent to the competent authority for application of mind, whether it has to go to the security force court or not, or it can be disposed of summarily, my lord.
Now, even if it is not done, matter goes directly to the security force court, will it become a ground for interference?
Yes, my lord. Judicial review power is there, my lord. If it is,
that is okay, but then what is the consequence of that?
Consequence will be that
the normal concept is that there should not be a denial of opportunity. That is what. Now, see, non-adherence to rule, which way it prejudices you, that also becomes important.
That's, my lord. There is judgment, my lord.
Yes.
There is judgment, my lord. If the procedure, which is the hearing of charge, my lord, which is a mandatory provision of law, which has to be heard, my lord, that has to be followed. If not, the entire thing vitiates, my lord. The entire procedure vitiates. That's held by the Supreme Court, my lord.
Give the citation.
My lord, that's not brought that today, man. It's Prithpal Singh Sethi versus Union of India.
But see, you are arguing, you see, like,
my lord, but that I will. It's Prithpal Singh Sethi versus Union of India, my lord.
Whatever it is, but you should come with that. This court will not go and find it out. You see,
no, definitely not, my lord. Definitely not.
This way, it's difficult. You see, we unnecessarily take up matters. We can start other matters also. If you are ready, it tells ready, we take up. Otherwise, you do not take it.
My lord, my friend agrees to a fixed date, my lord. I come prepared also accordingly. So many adjournments
see, giving fixed date is not only that your thing.
So
even the court's schedule also, that also becomes a matter. Sometimes we may fix a date, and you may think some other matter is consumed at that time.
Fixing the date also in the sense that they should cooperate, my lord, in disposing of the matter.
No, but then you see, like you being London Council, you are expected to have some sort of understanding when you will take up the matter and all. That understanding was always there, available. That is always there between the lawyers and all. So that is expected.
7-year-old matter, so 2016 matter.
He knows his fate. That is why he is not.
No, my lord. Why it was delayed? They themselves had on the. It was that after the court, they themselves has said that I will file by way an affidavit the proceeding of the hearing of charge and the Summary Security Force Court. At the later stage, after 2 years, my lord, they say that no, I will supply him the copy, my lord, the petitioner the copy. That is, they have supplied now. That is not before this honorable court. That what is the procedure has been followed, whether that it has been rightly followed or not.
That is a part of record.
No, they have not.
So where from it come then?
It is earlier in the by the order dated. My lord, I will.
Tell us when we can take it up. Just say. This is not possible, you say. But we'll simply see your petition and their affidavit and dispose of the matter. If you are agreeable to that, we can do that also.
My lord,
if hearing doesn't serve any purpose, what to do?
Definitely, my lord. They have provided.
At least you have to give something to the court. You have not given anything.
My lord, now this was provided. I can file it before the honorable court, my lord. This proceeding of the security force court, they themselves has undertaken by
that will be part of record. If you call for a record, it will be there.
Yes, ma'am.
That may be call for record, my
My
lord.
friend has to pinpoint that this is the infraction, this is the violation of the rules.
That is exactly what. These are the queries from the court. Right from the beginning, court is putting that question. What is the basis on which you have challenged it? What is to be done? Shall we continue? Is there any purpose? Any purpose we serve if we continue today?
Today, my lord.
I'll list it after. I do not know. This is something not very well. Let me see. The matter was taken up at some length. It seems learned counsel for the petitioner is not prepared with the brief. This is after 2 weeks. Please, Mr. Mojika, make sure you finish it. These are.
But for me, also, these matters have become like. I also want to finish my letter.
Please settle it and then please finish it. It is unnecessary.
Item number 6.
Obliged.
Item number 7.
Yes. Please, Your Lordship. Lordship, I'm seeking for
some accommodation, Your Lordship.
Now you see,
this case has become infructuous, Your Lordship. The publication was made in 2019. They want us to set aside that publication.
Oh, that bank
yes,
is
Lordship.
defaulter.
What is there to be set aside now? Since 19 it has been published.
I do not know what interest they have in dragging these matters. I do not know. Just see last order sheets and all, last few orders. They were asking time again and again and again. We will reject your prayer and dismiss it for default.
Because can you grant 2 more weeks, madam?
No, this is not possible. Just see.
Nothing
just see
left
this,
to be decided also, Your Lordship. With the passage of time, this matter has become infructuous.
My lord, one more opportunity be given, my lord.
Seems sometimes you also were not available.
I think a couple of times, Your Lordship. But not as much as them.
Then the court, there is an endeavor from the court to this thing on your submission to close the matter, but then you were not available on call.
Yes, that was accidentally. I happened to go out and then the matter was called.
Mr. So-and-so, Lord Counsel, appearing on behalf of the petitioner, praise for grant of further time on the ground of non-availability of Mr. Apple. It is submitted by Ms. T. Yangi, London Senior Counsel for the respondent, that there remains hardly in this matter. There remains hardly any grievance in this matter to be decided by this court. And in fact, the matter has become, after full stop, in fact, the matter has become, give a comma, in fact, the matter has become infructuous. Anyway, just give a full stop. However, for the hands of justice, one last opportunity is provided to the petitioner. List this matter after 2 weeks. You will not get. This is the last opportunity.
After 2 weeks, Your Lordship?
Yes.
Right.
That will be better, rather if you fix in very short days, then again.
It's up to Your Lordship. 2 weeks is.
Item number 11.
May I please, Your Lordship?
Yes.
My lord, this was a tender matter where, in my lord, first the tender was allotted, the contract was allotted to me after I successfully participated in the tender process.
Yes.
And then the contract was cancelled. Taking into account that
contract was cancelled or tender was cancelled?
Contract was cancelled, my lord. Once the tender is allotted, my lord, then the tender got dissolved into contract, my lord. This is my understanding, my lord. I am open to be corrected. My lord, may kindly see. There are 2 parts, my lord, in this matter.
Yes.
The first part is the tender which they have floated. I like to take, my lord, to Annexure 1, in page 14. They have cancelled the contract and they have blacklisted me also, my lord. And subsequently they have filed an affidavit. They said that they have scrapped the project. But I am aggrieved not only with the cancellation, my lord, I am aggrieved with the blacklisting also. Because that is a stigma on me, my lord. Now, my lord, the question my lord has to decide whether the wife and the husband can participate in 2 different identity in the tender process, and whether it is required to be disclosed or not, my lord. Whether the tender has such terms which says that if the husband and wife participate, that has to be disclosed, and if not, they will be disqualified. That is the...
That was a stipulation made. That is a condition stipulated. Was there a condition?
To ask, my lord, it was not there. It was not there. So I would like to take, my lord, to those papers which has been enclosed with the tender paper. My lord, may kindly see Annexure 1, page 14.
Yes.
On 26th September 2018, my lord, the DG Assam Rifle
on behalf of the President of India, has floated a tender, online tender, my lord, this was, and we have uploaded our tender papers, my lord, by the name of MS Lal Monty, Lal Monty Enterprise, my lord, and it is a sole proprietorship, my lord, of this farm. Now, my lord, may kindly
was for what? It was
for construction, for shooting range, my lord, indoor shooting range, my lord, composite indoor shooting range, my lord.
Composite indoor shooting range.
Yes. My lord, may kindly see that on behalf of the President of India, the Director General of Assam Rifle, Shillong, invites online tender under 2-bid system, technical and finance bid on the prescribed form for the purchase of the following stores. The following store is one number only, my lord. Composite Indoor Shooting Range, CISR, my lord. And this tender was floated on 26 September 2018, my lord. On 18 November 2018, my lord, I have submitted my bid. Along with the bid, my lord, Appendix L, which was with the tender paper, was very pertinent, my lord, to decide this matter, my lord. My lord, may kindly see page 29. Appendix L, Chapter 6.
Obstructive practice.
Yes, my lord. Page 29. My lord, may kindly see certificate for abiding by Code of Integrity for Public Procurement, CIPP, is the head note, my lord. My lord, may kindly see that this is the document which I have to give a declaration. So we have given the declaration along with my tender paper with this format, my lord. My lord, may kindly see that on what basis, my lord, they can restrain me to participate in the tender process is by corrupt practice. They have defined what is corrupt practice, what is fraudulent practice, and anti-competitive practice. My lord, may kindly see serial number 5, conflict of interest.
Yes, go on.
My lord, I will just read out, my lord, this clause. Participation by a bidder firm or any of its affiliates that are either involved in the consultancy contract to which this procurement is linked, or if they are part of more than one bid in the procurement, or if the bidding for a firm or their personnel have relationship, my lord, or financial or business transaction. So my wife and me, my lord, I have a relationship that is a personal relationship, my lord, not in connection with the business or financial transaction, my lord. It's two different identity, my lord. But they have taken the shelter of this, my lord, to cancel my contract. Now, my lord, the background of the case is this, my lord. After giving me a contract, they have cancelled my contract after a period of 1 year, whereas they was very much aware that we was husband and wife. Now, my lord, may kindly see how the contract can be terminated. My lord, if my lord kindly come to serial number 2 of the same page.
Yes.
At any stage, if found in case of any transgression of this code of integrity for public procurement.
Same page 29.
29 only.
Oh,
the last
yes,
last paragraph.
Yes.
At any stage, if found in case of any transgression of this code of integrity for any public procurement, as mentioned above, shall be not only liable to be removed from the list of registered supplier, but will be liable for any punitive actions such as cancellation of contract, ban and blacklisting in Competition Commission of India and so on. Rule 175 of GRF, General Finance Rule, my lord. My lord, if my lord may kindly see General Finance Rule, they doesn't say that if the relationship is between husband and wife.
But then this is a declaration by you.
Yes, this is a declaration by you.
This is a part of the declaration by you.
Correct, my lord. Correct. Now, in this declaration, this is the format which they have uploaded. They have not mentioned anywhere that I have to disclose that if my wife also participate, or my son or my brother participate, that I have to disclose. In this form, nothing has been mentioned of that. Only I have to sign and seal, my lord, and enclose with my tender paper. My lord, if my lord may consider 175 of the General Finance Rule, my lord.
Where is that? Is it there appended anywhere?
We have. Is there? They have quoted in their affidavit, but I have the book.
They are referring to this 1, 2.
Now let me kindly see 175(1)(2) of General Finance Rule 2017. My lord, may kindly consider clause D of the section 175.
Improper use of information.
No, my lord. They have relationship with each other, direct or through common third parties.
That is clause?
They have quoted is
175, 1 subclause 2.
2.
It talks about conflict of interest.
Number 2. Roman 2. Small Roman 2.
Yes.
Disclosure of conflict. Okay.
Yes.
And under that, D.
There is no D under
there is no D. It is
there is no D under
that.
that.
Of course. No, my lord. That under this section, my lord, they can terminate me. But here in this section, my lord, they have not mentioned anything that the husband and wife cannot participate.
No, how can it be? See, it may happen husband and wife, they are in separation. Will it?
Yes. Now, my lord,
it may happen like that. Just because you are related husband and wife.
Yes, my lord.
See, that relation has to be business relation.
Business relation, my lord. Exactly, my lord. Now, my lord, may kindly consider. Now, this is the background of the case, my lord. Now, my lord, I would like to take my lord to each and every page, which is very relevant to.
The reference to 175 is only for that.
Yes, my lord. Yes. Now, my lord, I would like to take my lord to each and every provision of the tender, which will be very pertinent to decide this matter, my lord. My lord, on this tender process, my lord, there were 4 farms. 4 farms participated, including my wife. Now, my lord, out of this 4 farm, my lord, on 20th November 2018, the Technical Evaluation Committee, they said, and they have selected 3 farm out of this, my lord, and 1 was rejected. The farm which was selected is my farm, Lal Monty Enterprise, GSG Associate, and Paramhans Private Limited, my lord. And 3 farm was to be considered for the tender process, my lord. Now, my lord, on 3rd January 2019, detailed project report was sought from all the 3 farms, my lord. On 25th January 2019,
now, out of 4,
1 was
this was under, this was the excluded after consideration technical bleed, or?
Yes, my lord. In the technical bleed, there was other parts also. In the first round, he was eliminated.
As per the
documents was not found to be correct.
There has to be 2-bit system.
2-bit system, technical and finance.
Technical and finance.
Yes.
So once you overcome technical, then
only finance will open, my lord. Yes.
Now the exclusion of 1.
Yes, my lord.
It was at what stage?
Technical bit, my lord. Technical bit also there are different stages, my lord.
Yes.
In first round only he was eliminated.
Yes.
Because he could not submit certain documents, my lord. Okay. Now, my lord, on 3rd January 2019, details project report was sought from the said 3 farms, my lord. And 25th January 2019, technical evaluation team of DPR carried out, my lord. And then Paramhans Private Limited was on the 3rd round eliminated, my lord, in the technical process only. So, my lord, now only 2 farms remain, my lord.
2 farms were eliminated in technical.
In the technical, my
at the very beginning one and at the middle stage of this.
Yes. My lord. Now, my lord, only 2 farms remain. That is my wife and my farm, my lord. Now, my wife and my farm, my lord, different GST, different office, different identity altogether, my lord.
Your wife has separate business identity.
Yes, my lord. Different GST, different PAN card and all everything. And earlier round also, my lord, they have participated. If the record is called, my lord, that will be more feasible, so that, my lord, it can be examined. Yes, my lord. Now, my lord, may you kindly see on 5th February 2019, finance bid of the remaining 2 firms was opened. 5th February 2019. On 12th February 2019, my lord.
These facts are there in your petition? It is mentioned, all those facts, dates wise?
Yes, it is mentioned. Yes. Now, my lord.
Your moving fight court is not in a position to note all those things. So it has to be there.
Yes, my lord. I have mentioned, my lord. And if required, I will give a small synopsis also, my lord.
Yes, that will be very good.
Yes, my lord. Now, my lord, on 5th February 2019, finance bid of the 2 remaining firm was opened, my lord. 12th February 2019, my lord. Paramhans Private Limited, my lord, that second firm who was out, my lord, he lodged a complaint against of me through the MHA, my lord, that we are husband and wife. He brought it to notice.
Both of you, against both of you. Complaint was against both of you.
Yes. Otherwise, it is against both of us.
Now, what happened? One thing, just for a query. Now, you were blacklisted. Whether your wife was also blacklisted?
No, my lord.
Why?
That instruction I have to complete. Not in this order.
No. Your wife is not a party here.
No.
But then supposing if some disclosure or non-disclosure has some effect on you, then it should also have the similar effect.
Probably, my lord, yes.
But then your wife was spared.
Yes, she was also blacklisted. But she is not before this honorable court.
It's all right.
My lord.
It's a normal query.
Yes, my lord. Now, my lord, on 12th February 2019, this is very important date, my lord. 12th February 2019.
12 February 2019.
Yes, my lord. Paramhans lodged a complaint. Paramhans is the second firm who was eliminated in the technical round, my lord.
Okay.
He lodged a complaint through the MHA, and on 15th February, my lord, they was asked to provide a comment. It is the Assam Rifle who was asked by the MHA, my lord. It was interdepartmental communications and all, my lord, that we doesn't have much information until unless the file will be produced before this honorable court. And there was an order of this honorable court, my lord, to produce the file also, my lord. The file was examined by the other court, my lord.
Then the file was returned. Record was returned.
Probably the file will be with my senior friend. Now, my lord, on 18 February 2019, Tender Purchase Committee chaired by DGR recommended and awarded the contract to me, my lord. After the complaint, my lord, that is why I say that 12 February 2019 is a very important date.
Complaint on 12 February, 18 February, contract was awarded to you.
Contract was awarded to me, my lord. And on 20th February, my lord, offer letter for procurement of CISR was issued to me, my lord. That is work order. That is on page 30 of my writ petition, my lord.
When?
Page 30 of my writ petition.
Yes.
20th February 2019.
The same day, the work order was issued over.
Yes. This is an offer letter for procurement of composite indoor shooting range, CISR, quantity 1 number. So this was the order which was issued to me. Subsequently, on 22nd February 2019, my lord, another letter was issued. That is a supply order. That is on page 31.
Yes. After the offer, was there any need of executing any agreement?
No, my lord. No.
No need.
No need, my lord.
And then supply order was supplied.
Yes, supply order on 22nd February 2019.
What happened to supply? You responded to it. You made supply.
Yes, my lord. Make supply and supply for making the shooting range, my lord. There are some materials are required, so I have purchased it and then I have supplied, my lord. And the total amount of material which is lying at present with the Assam Rifle is 7.41 crores.
Not a part of your pleadings.
That is not pleadings. We can file an additional affidavit to bring.
No, if it is required, we have to see. I don't know.
My lord, I will just check. My lord,
just let us remain confined to the subject matter which is before this court.
Yes,
let us not go here and there.
Yes, my lord. Now, my lord, we can see after this complaint, first complaint, second complaint was also filed by the same party.
Okay.
And then, my lord, a letter was issued on 25th.
Where is these complaints are where? These complaints are appended with.
No, we don't know, my lord, but we was informed, my lord.
Now, consequent to the filing of the complaint, you have not been asked to file your response.
Show cause. Yes.
So, but then how you can file a show cause without copy of complaint be provided to you?
My lord, may kindly. We have been issued with the show cause notice only, my lord. Complaint was not.
So you did not ask for that also. You did not ask for that.
Probably we have not asked because of the COVID scenario at that point of time, my lord.
What about the reason? You have no fact remains. You have not asked. You have not bothered to see the complaint when you file your reply.
The complaint is husband and wife, my lord. Basically, the complaint. I will like to take my lords to the complaint.
No. If you know the contents of the complaint, then non-supply has no meaning.
Yes. Because they have.
You do not have any grievance against non-supply.
No. We have no grievances, my lord. Because we have not raised this point. I cannot bring a new thing.
Yes.
Now on 25th February 2019, my lord, page 39. They have addressed a letter to me. Page 39.
23rd February.
25th, my lord.
25th.
And this is 2020. Now, my lord, we currently consider the dates when the work order issued to me. February 2019. My lord. February 2019.
Your work orders was 18/2, isn't it? Oh, sorry, February 2019.
Yes.
Is 20th February. No,
yes.
This is
20th.
Letter for procurement.
Yes. One is 20th, another one is 22nd.
Now, your submission was that you were to contract on 18/2.
Sorry,
18 February.
Yes. 18 February, my name was forwarded.
There is no document. Is there any document?
No, we have not enclosed those documents.
So, as per the records, it is 20th.
Yes.
By which the offer was
given. Issued. Yes. Now, on 22nd, my lord, supply order was issued to me. And my lord, may kindly see on page 39. This letter dated 25 February 2020. Almost after a period of 1 year, they have acted upon the complaint for the best reason known to the respondent. Why after a period of 1 year, my lord? They have issued me a show cause. That, if I am permitted to read, my lord.
Yes, why not?
Violation of Code of Integrity for Public Procurement, CIPP, in tender number so and so, dated so and so. Number 1, my lord. It has been reported that Messrs. So and so, proprietor of GSG Associate, so and so complex, Kitting Road, Police Bazaar, East Khasi Hills, Meghalaya, 793001, is related to you as your wife. That is first contention. You are therefore called upon to confirm the same within 7 days of issuance of the communication. In light of the certificate for abiding by Code of Integrity for Public Procurement signed by you as per Appendix L, page 39 of the NIT. In case no response is received from your end by 7 days of receipt of this communication, the report of so and so is your wife will be deemed to as confirmed. That is a fact that I cannot say no that she is not my wife.
Definitely.
Now my lord.
The show cause is only confined to one thing. Either you say yes or
yes or no. Yes.
Nothing more than that.
Nothing more than that. Now, my lord, in the next page, page 40, I have replied to them. And we have admitted, my lord.
You have to. If it's a fact, you have to. There is no other option for you.
Yeah, I cannot say anything more than this, my lord. Now, my lord, may kindly see on 17 March 2020, that is on page 42.
Your reply is dated?
Yeah. My reply was dated, my lord, 2nd March 2020. The first reply. They have issued
page 40. Is it page 14?
Yes, my lord.
What is the date?
Date is 2nd March 2020. My lord, may kindly see violation of code of subject and then letter number.
No, that is doesn't say about your. Is it your letter number?
Yes, this is my letter number, my lord. This is the date. What? Letter number dated so and so, my
after
lord.
Subject you have written.
Yes, after the subject.
This should be construed as your memo number. This is.
Yes.
No. Are you sure?
Yes, my lord.
Say this LME, this is CISR, these are all your.
Yes. Because the communication, there was a department communication. LME is Lamonte Enterprise, my lord.
Okay. This is letter number.
This is the letter, 2nd March 2020. Now, my lord, may kindly see this on page 42. That is letter dated 17 March 2020.
Yes.
They have issued a show cause. Show cause for what, my lord? Termination of contract agreement against tender notice number so and so dated 26 September 2018 and corrigendum dated 26 October 2018 and 12 November 2018 and consequential action.
Now, is it termination of a contract agreement?
Yes.
There was an agreement.
No, there is no agreement, my lord. It's a contract. Now, my lord, may kindly see para 1. Whereas the bidder were required to mandatorily avoid any conflicting practice, comparative practice and conflict of interest and render as undertaken certificate of Code of Integrity for Public Procurement CIPP as per Appendix L of the tender documents that they will not be only be liable to be removed from the list of registered supplier but also for the punitive actions such as cancellation of contract, ban and blacklisting or action in Competition Commission of India and so on, Rule 175 of JR General Finance Rule of 2017, my lord. This was the show cause which was issued to me and they have just quoted, my lord. That Appendix L they have quoted. Now, my lord, may kindly come to page 44. The rest are all, they have quoted the Appendix L. Page 44, my lord.
Yes.
Whereas the entire matter was placed before the Director General Assam Rifle, being the contract approving authority, who has, after due deliberation and consideration, is of the view that your company owner proprietor, by intentionally and knowingly suppressing the fact of his being the husband of so and so. So they have said intentionally and knowingly we have suppressed that we are husband and wife. Now, my lord, be kindly considered.
Yes.
And Appendix L. They have not mentioned anywhere in that we have to give an undertaking or we have to disclose that I am a husband and wife.
See, so far as Appendix L is concerned, it doesn't even say just merely because somebody is related as husband and wife,
you cannot be disqualified. Yes, my lord.
The conflict of interest, if you see, it speaks about something.
Yes.
You see, like participation by a bidding firm or any of its affiliates that are either involved in the consultancy contract.
Yes.
To which this procurement is linked.
Yes.
Or if they are part of more than one bid in the procurement.
Yes.
Or if the bidding firm of their personnel have relationship or relationships or financial or
business transaction.
Now, have relationships. What do you mean by that?
It is a corporate relationship.
Now, that is where is the thing is that. See, that is probably that is the only thing which this court has not still now. Otherwise, nothing is there which may bar a husband and wife.
Correct, my lord. This is the only thing, my lord, relationship. And the relationship which contemplate in this letter.
It means if two brothers take part, they also will be barred.
Any member of the family, it appears. But they have not said anything categorically, my lord. Now, my lord, may kindly say.
Can it be? Is it not that you interfere with somebody's individual right?
Definitely.
Two brothers may say, supposing if you go by relationship, and that clause diverts two brothers from taking part. Now, brothers may have their individual profession. They have individual business things. Can it be? I do not know what is that relationship means.
They have two different identities, but they are brothers. Can they be barred?
Or their personnel have relationship. No, see, their personnel have relationship. Now, what would be meant by that?
The personal, it has to be in terms of the corporate relationship, my lord. It cannot be.
Their personnel means the personnel who are involved with the business. See this?
Yes.
PRI, so double NL.
Yes.
Anyway.
So, my lord, now, my lord, may kindly come to page 44. Whereas the entire matter was placed before the Director General of Assam Rifle,
Yes.
being the contract approving authority who has, after due deliberation and consideration, is of the view that your company ownership, proprietor, by intentionally and knowingly suppressing the fact of being the husband of so and so, proprietor of Messrs. GSG Associate, Kitting Road, Puli Bazaar, East Khasil District, Meghalaya, Shillong, has breached the terms of the subject contract agreement, necessitating show cause action as to why the award of subject contract be not terminated, with the consequential action for recovery of the public fund released to your company by an other under the authority of the Director General of Assam Rifle for the incohesive contract, as also the blacklisting of the company, debarring it permanently from participation in any tender action for procurement of whatever nature within Assam Rifle. Now, my lord, with this notice, my lord, they have given me another 30 days time to show cause why I should not be blacklisted, why the contract cannot be cancelled, my lord. It should not be cancelled, in fact. Now, my lord, I have replied to them on 24/5/2020. That is on page 45.
Yes.
Now, my lord, these are all general
I
averment.
have taken that. What is your plea in that your reply?
My lord, may kindly see page 47.
Yes.
Page 47. With regard to the content of para 2 of the notice under reply, I state that it is true that I have.
Para 40?
No, page 47, my lord.
Page 47.
Yeah,
yes.
The relevant portion of my reply, my lord. I am reading
Yes,
the relevant portion.
With regard to
para
the
5.
Yes.
With regard to the content of para 2 of the notice under reply, I state that it is true that I have furnished a certificate of code of integrity for public procurement as per Appendix L of the tender documents along with the bid. I state that my bidding process has strictly adhered to the content of Appendix L and have not violated any of the provision of the same. With regard to content of para 3 of the notice under reply, I state that it is true that I have received a query whether so and so is my wife, to which I have confirmed that the same to be true. Though my reply dated 2nd March 2020, however, the above fact shall not render the certificate submitted in Appendix L as false and misleading as alleged in your notice by a stretch of imagination, as I did not state anything which is false or misleading in the entire bidding process, and the said contention is absolutely unfounded and uncalled for, leave alone using the show cause notice under the sole ground that so and so is my wife. Now, my lord, para 7 and 8 is where I have clarified, my lord. With regard to the content of para 4 of the notice under reply, I state that it is not specified as to what material was placed before the Director General Assam Rifle, but para 4 of the show cause notice state that the Director General Assam Rifle is of the view that my company is intentionally and knowingly suppressed the fact of being.
Yes. All right. Then. Okay. Then,
my lord, I have stated in para 8 also I have stated.
Yes.
That what is the position, my lord. Then what they have done, my lord, on 27th May 2020, my lord, they have passed an order. That is the impugn order, my lord.
Yes.
Now, my lord, may kindly see the relevant portion is on page 55.
Wow. Such a big order.
Big order, my lord. It appears someone has written for them.
What about
they have applied their mind correctly.
Taking into consideration the issue and the order. You see, that is, it seems quite.
First time I have seen such a big termination order.
If short order, he'll say no application of mind. If it is short order, he'll say there is no application of mind. It's not a speaking order.
No, that's why they have taken the opinion of some good lawyer, probably. So they have passed this order.
Any known lawyer you suspect?
They're entitled to that.
Yes. Please carry on. Yes,
pulling
page
the legs
55.
aside, my lord. Now coming back to
Yes,
the
page
issue.
55.
Page 55, my lord. Para 11, my lord. Therefore, notwithstanding the fact that some part of the contract work has been underway with supply of some storage payment made to so and so cannot be permitted to continue with the contract in question, and I have to thus without any discretion terminate the contract at this stage of execution without any financial liability and pass the following orders. Now, my lord, this order was passed. Then how much amount they have given me, how much material I have given, my lord. Now, my lord, may kindly see the next page, that is on page 56.
Yes.
If my lord consider clause E.
Yes, a criminal complaint.
A criminal complaint will be filed with the jurisdictional police station against so and so for committing fraud against the Assam Rifle. This was stated by this honorable court on the motion.
What is that fraud?
They said it is a fraud, so they have
non-declaration.
A non-declaration. Yeah. Now, my lord, it appears, my lord, if I go and participate, I have to put a placard. She is my wife. She is so and so. It appears they have not stipulated anything.
Not exactly to that extent, but then whether the mere fact that there is a relation, there is a between two participants, whether by itself would become a bar for them.
Yes,
that is what.
Yes, madam. That has to be considered by this
individual right. If it is to be interfered, there must be some genuine reason for that. So
I'll answer that.
That is what the query of the court, not the finding of the court.
My lord.
If my lord, can you consider this order? I know this will have no much bearing on this, but para 17. You have? No?
What is that?
This is an order passed by Competition Commission of India, my lord. My lord, may kindly see para 17.
Yes.
It is further observed that as per the past decisional practice of the Commission, such allegation and instance have been found to be insufficient to even prima facie establish contravention of the provision of Section 3 of the Act, that the Commission in so and so has held that mere communality or directors of directors or ownership of a particular firm in itself is not sufficient to record any prima facie conclusion about bid ringing in the absence of any material indicated collusion among such bidders while participating in the impugned tender. Similarly, the circumstances that OP number 9 and OP number 10 are located in the same area in itself is of no consequences in the absence of their material established concern behave. Further, in so and so, my lord, the Commission has held merely having a common business linkage between the OP as projected by the informant cannot be the basis to suggest collusion in the bidding process. Moreover, there is no material on record to suggest that the OP were engaged in bidding ration, etc. Yes, my lord.
Bid rotation.
Yes, rotation, etc. Therefore, the allegation of so and so bid does not find favor with the Commission. Even if they, my lord, they are part of the same farm, my lord, but if there is no such material place, now my lord has to examine from the file, my lord, whether there is any material, because no material was supplied to me. I don't know, my lord, what was before the DG of Assam Rifle. Show cause doesn't say anything about any material was placed. Show cause has not said. Show cause is only in one line, my lord. They have sing the song that she is so and so and she is your wife, and you have not disclosed. But under what provision of law I was required to disclose, or what was the format for disclosing, my lord? Because these are all online, my lord. I cannot insert anything new on this. So whether that is permissible or not, my lord.
No, they are saying it is clause 5. See,
they are saying it is clause 5, my lord. Now, my lord has to examine whether that clause 5.
That is what this court will examine.
Yes.
Definitely, this is precisely the case.
Yes, yes.
Just because that there exists a relationship,
yes, my lord,
between two bidders, whether by itself would disqualify you.
Yes, my lord.
But that is what is.
Now, my lord, there are two files. On being instructed, I am submitting because, my lord, last time also by the other judge, my lord, Honorable Justice, thank you. He has called for the record on 21st/4/2022.
Yes.
21st/4/2022, and the record was placed on 9th 6 2022. And it appears, my lord, because the petitioner was present, it appears there is two files, my lord. There is a tender file where the entire thing has been done, and there is another file which is called vigilance file, my lord. When the complaint was lodged, my lord, the first complaint, after that they have given me the contract, they have awarded the contract to work to me. It's not that it was out of their knowledge or no one has brought into their knowledge. Okay, fine, I have not disclosed, my lord.
It may happen like that. The complaint was filed in one section, the order was issued by another section.
No, my lord. The vigilance file, my lord, has to be considered before you award the contract, my lord.
So anyway, now whatever the case, but matter seems like the issue involved is only that much.
Only that part, my lord. Whether this relationship is a corporate relationship or your personal relationship.
Your blacklisting was for indefinite period of time.
No, it's for 2 years, my lord.
So it is over now.
It is over now, but they are still.
It is for indefinite, subject to review after 2 years.
Oh, it is for indefinite, my lord. I'm correcting, my lord, sir. That it is for indefinite period, my lord, but subject to review after 2 years.
So there is no review.
There is no review, my lord.
When this blacklisting took place, what is the impugn order?
My lord?
Impugn order is dated what?
Impugn order is 27 May 2020.
So it has not been reviewed.
It has not been reviewed, my lord. I have approached, my lord, for an annual maintenance contract, my lord. But they are not entertaining me for that also. They are not even allowing me. Whereas there was already a contract for annual maintenance, my lord. But they are not entertaining. They said the matter is pending before this honorable court. So let the court decide, then only we'll see to it. Now, my lord, one more point which is required to be considered by this honorable court is this, my lord. Even if it is reviewed. Now, my lord, I was declared as blacklisted. And in certain contracts, my lord, central government contracts or state government contract, where you have to give a declaration that you have not been blacklisted in the last 5 years. Now, another 5 years, even if it is reviewed, and they consider my prayer, and I will allow to participate, but another 5 years term.
No, that stigma will remain there.
The stigma, my lord, the stigma.
Whether it is operational or not,
yes,
is a different thing, but
yes,
that will remain.
Yes.
And that may hamper you in your future.
That will hamper me. That is why I am before this honorable court, my lord. Now, my lord, another part is this, that the amount that I have invested, I paid a GST of 46 lakhs. How much? 61 lakhs GST. Because we have to pay for GST, then only we can procure the items. And the material which I have procured, my lord, I have purchased to supply to Assam Rifle, it is still lying with the Assam Rifle. And they have not said anything on that also, my lord. So it's a total, like, they are not only banning me for participating in the process, there is a financial loss also to me, my lord. Now they say that we have scrapped the project. You can scrap the project. You have every right to scrap the project. But the damage which has been caused to me, my lord, who will consider that, my lord? That is why I am before this honorable.
The scrapping of project is after some work was done.
Work was done. And moreover, my lord, after cancellation of my tender, of my contract, they have floated the tender.
Again for the same work?
For the same project, my lord. For the same project, they have floated the tender. And then, my lord, what happened? Mr. X or Y, he has participated and it was offered to Mr. X, but he has not completed the tender. Means he has not accepted the offer, my lord, given by them.
So things remain unallotted.
Yes, my lord. Only now they have said on oath, my lord, they want to scrap it, my lord. Only thing is this: if my learned senior has the file, my lord, the record, that is required to be examined by this honorable court, my lord, because it was already called for. So if he can produce the file, my lord can examine.
Record, okay, if it is required, it will be produced. But then that part would be more important for him to clarify. That's mere existence of relationship between parties.
I'll reply to my friend whatever he submit. If I have something.
Because if record is required, we have to, before we take a decision, we will definitely see the record.
Yes, my lord.
But then even then, just
because the record will clarify, my lord, whether before awarding the contract to me, whether they was aware of that relationship or not. If they was aware, they could have blacklisted me, and there would have not been financial anybody.
Okay, you are stretching that thing further, but then right now the court query is confined to that. What that relationship means?
Let him.
Now, whether that will debar to brothers also from taking part or not?
My lord.
It will. Can it be valid? No, but then that clause is not under challenge. That clause,
my lord,
puts that restriction.
My lord.
That is not under
clause is not under challenge. My lord. My lord, in my humble submission at this stage, my lord, there are two very important developments, my lord, during the pendency of the matter, my lord. The blacklisting or debarment was initially for 2 years, my lord, subject to review. And secondly, the department has taken a decision to abandon the project, my lord. The ministry has cancelled the project now because of the delay caused because of pendency of the matter also and certain other factors also.
They submitted that there was again retendering of the thing.
My lord, that retendering was done with the leave of this honourable court, my lord. I can place that order.
No, that is okay.
We have obtained leave from this honourable court that we can retender.
See how these two things will go together.
My lord, that was quite some time back, my lord. It is not recently. That must be around 2021 or even 2020, my lord. I can just point that out. But after that, now ultimately a decision has been taken and the project has been cancelled, my lord, abandoned. They don't require this shooting range anymore, my lord. So, my lord, what relief can be granted at this stage by this honourable court, my lord? That is the first submission, my lord. Number one.
No, we can interfere with the order of this thing, stigma.
My lord, stigma lordship can interfere with. I can accede to that extent also, my lord, because GFR 175 only gives the power to debar for 2 years, my lord. The 2 years has been over. Even if lordship interferes,
no, totally, even for the 2 years also, totally that should stand erased.
My lord, that is one aspect, my lord. That I leave to the discretion of lordship, my lord.
There will be no opposition to you,
my lord.
The opposition by you, so far as that part of the
that part can your lordship. If your lordship come on merit, your lordship comes to a conclusion that this was unfair, my lord. But I'll make my submission, my lord. That
no, what this court basically is interested to know at this stage is about that relationship and how it can be like.
My lord.
What is the
my lord? Rules say that
can legality be attached to that kind of.
My lord, rules say, my lord, if they have access to information of each other, my lord.
How do you determine it?
How you determine, my lord? If your lordship looks at the prices quoted by them, my lord, so close, my lord.
So a finding has been recorded by your department before you came to the decision.
My lord, in so many words, the finding has not been recorded, but lordships can examine that how close the prices are, my lord. How close the prices are, my lord.
No, but then there has to be an assessment of that. Even if you say that, your submission will not suffice. There has to be consideration of that by the department which has taken decision to debar him. See, you are an expert. Once it falls in your hand, you will definitely scrutinize it and you will give it.
My lord.
But then what is important is that the department had considered that aspect at the time when they took a decision.
My lord.
The legality of the decision will depend on that. Once it is in your hand, we understand.
But I'll take your lordship to the entire order, my lord. My lord, only one aspect. My friend has taken a lordship to page 29, my lord, the CIPP, Code of Integrity Pact, page 29 of the writ petition, my lord.
See, this court has not taken note of all the submission of Mr. Day, though it remembers it.
I will give a synopsis of this,
because otherwise we are moving quite fast.
I'm sorry,
very difficult because you know your case and the court doesn't know.
Well, I will give a synopsis.
Yes, that would be better. It would be helpful. Yes, page 29.
My lord, there are two relevant clauses here, my lord.
Yes.
One is clause 3, anti-competitive practice.
Anti-competitive practice, yes.
It says, my lord,
any collusion,
bid rigging, or anti-competitive arrangement or any other practice coming under the purview of the Competition Act 2002 between two or more bidders with or without the knowledge of the procuring entity that may impair the transparency, fairness and the progress of the procurement process or to establish bid prices at artificial non-competitive levels. This is where in my humble submission, my lord, that case is squarely fall, my lord. And then clause 5
but then your Soko's notice was confined to that thing you admit whether such and such is your wife or not.
My lord, that is the fundamental, my lord.
But then it had nothing to do with these things. There is no reference of anti-competitive practice there. Your show cause is confined to one thing, and now you are widening it by referring to this.
But that to some extent, my lord. But
see, you cannot improve it. It is already provided there. See, so anyway, proceed.
Then my lord. Well, this is my submission, my lord.
No, that is okay. See, even if you say that also,
my lord,
then we will definitely require the record to be produced,
my lord,
to see whether, because this will be burden on him. He has signed the certificate. Now, in spite of that, if you say that he has done something, then it is burden on his new to show on whichever. Now, prima facie, what is there? Now, if you say that if you see that the prices quoted by them, now it may happen that you see some other bidder also quoted more or less similar price. Just because there is a quotation of more or less similar price,
my lord,
can you be present?
My lord, there are two aspects, my lord, which reinforce the factor, my lord. Firstly, they are husband and wife, my lord. My lord, if they are not husband and wife, there are two separate entities from different places of the country, my lord. In that case, maybe there is a
degree of suspicion would have been less,
my lord. But here the scope or degree of suspicion is more, my lord. Now, my lord, to say that husband and wife will not have information about how much they are quoting, my lord, this is one thing in my humble submission I cannot believe.
But then you see, your submission makes a case for him moment you refer to clause 3 here,
my lord,
because your show cause is confined to one thing and you reference is to something else. Anyway, it's all right. Carry on, please.
Now, my lord, if your lordship comes to the Competition Act,
this Competition Act,
well,
it takes care of which competition? Competition in which area?
Competition Act 2002, my lord.
Yes, sorry.
My lord, section 3.
The Competition Act is applicable in the present proceedings. It applies to all the commercial transactions.
My lord.
Everywhere, throughout the country.
My lord, here, what is called anti-competitive agreement, my lord, section 3 defines.
Yes.
And coming to clause 3, D, my lord.
Directly or indirectly result in bid rigging or collusive bidding.
Collusive bidding, my lord.
No, but then that requires proof.
Now, my lord,
if you have to hold,
my lord,
that somebody has indulged in bid rigging and collusive bidding,
my lord,
in such a case there has to be proof. There has to be something, at least some materials.
My lord, there are two materials to that, my lord. That the number one, their husband and wife, and that the bids are too close.
What happens if they are separated?
But that's
how do you determine that?
But that's not the case here, my lord. They are not separated. Because in one of the cases, my lord, the Supreme Court dealing with Competition Act says, my lord, this has to be inferred from the facts, my lord. There cannot be a direct evidence that there was a bid rigging or bid collusion, my lord.
No, inference cannot be unreasonable. That has to be inferred definitely. There is no other option.
But there cannot be any direct evidence to that effect, my lord, whether they actually collided.
No, you can say that they have never raised that thing, that they are in separation, they are in not in good terms. So in view of that, it can be. Definitely. So that inference, your inference will become more stronger.
My lord.
Now you see what is falling from this court is basically the queries, not
my lord. My lord. I understand.
Okay, but then whatever it is, whatever it is, cannot be bereft of any proof. You see, it has to be proof. There has to be proof. Proof means this is not a kind of proof beyond reasonable doubt. But then there has to be prima facie material. Even if you want to say that there was a bid rigging and collusive bidding. Now, if you say that has been drawn on the basis of comparison or a basis of a competitive chart made on the basing on their documents.
My lord, the prices are so close, my lord. I can just inform your lordship what the price is, my lord. 18 crore 79 lakh rupees in 18 crore 90 lakh rupees. That's not.
You have stated all this in your affidavit.
It's not on affidavit, my lord. This fact.
Mr. Mojikasi, this would be too much for you. You see, if something is not there on record and something is not in the affidavit,
these are on record, my lord.
I think this will remain only in your submission. We may record it, but then we will discard it, saying that there is nothing on it.
My lord, here what happened, my lord, for last so many dates, my lord, when it was informed, my lord, to the Honorable Court that we have taken a decision to abandon the project, even on the last occasion, your lordship observed that now the only remedy that is available to them is to file a suit for damage, my lord.
No, that is all right so far as their loss is concerned, my lord. But then say, supposing that debarment has some sort of stigma, then,
my lord, what I would pray, my lord, if the matter is taken up,
then you can do one thing: tell your department to reconsider it, erase that. Then court will not pass anything.
And for the remaining relief, they can approach the trial court, my lord, for the civil court.
No, for financial damages and all, definitely this court will not be in a position to determine it. Even if we can, establish a prima facie case, that will be quite difficult for a state court to go into all those things, because there will be always assertion and denial by you, my lord. But then, so for stigma part, if your department takes care and if you are ready to erase it, then it's all right.
Because our case on affidavit is, my lord, that they've done the work only of 11 lakh rupees or 11 to 12 lakh rupees, my lord. Whereas 50% advance was paid to them. Some money has been recovered to them by encashing their bank guarantee and other things, my lord. 2 crore something, we had to file a civil suit, my lord. We have already filed a civil suit for recovery of that. Against
and it's okay, but then see, we'll just see that stigma part. What can you do?
Only stigma part is, in my humble submission, only that part is left, my lord.
So
my lord, but my understanding will be this, my lord.
The criminal prosecution, my lord, that has been stated.
No, not only that.
That can be set aside also, my lord. That part.
That not only that, my lord, but the issue, what is before my lord, whether that relationship cover the husband and wife or not. Now, my lord, in future also they will take this.
In such a case, there has to be a challenge to that particular clause.
My lord,
there is no, admittedly, there is no challenge to
that. But my lord, at that point of time, what I have insisted on is the complaint, the first complaint. The first complaint disclosed that I am a husband and wife. The first complaint disclosed. Even then, they have given me the work order. Now, can they take a U-turn? Can they take a U-turn and say, no, you are husband and wife, we are going to cancel your contract?
That's not correct, my lord.
No, that is the correct position, my lord. That is the correct position. I will place the record.
First complaint, which was received by us before issuing the supply order, that complaint submitted by Paramhans only talked about some.
Where is the complaint? Complaint is there in this thing.
Yes.
Where is that? What is?
No, the complaint is not there with us, my lord. It is the show cause notice which they have given on the basis of the complaint.
No, but then where is the complaint then?
Complaint is with them, my lord. Probably.
So then you are referring to certain complaint now.
No. What I am saying is this: the date we know that on that date a complaint was lodged before them, disclosing that we are husband and wife.
That complaint did not disclose, my lord, that they are husband and wife.
Then
second complaint.
What basis this court will determine?
Second complaint disclosed that they are husband and wife, my lord.
You do one thing. I think it will be better to produce record.
Record will be very pertinent, my lord. That's why
records were produced on several occasions, my lord. I can place again. But today it was understood that
produced in such a way so that we can get it disposed of.
Yes,
it is not.
I will also make my synopsis.
It will be something like for academic discussion we do it and all. And at least the submissions, if you confine yourself to the materials on record.
My lord, now only one thing, my lord. If they are happy, if they are agreeable to this proposition, my lord, that we recall that blacklisting part, my lord, and for the rest of the relief,
so that is on you. Whether they agree or they do not agree. That is on you. Once you do it, definitely this court will have no reason to interfere with, my lord, that part.
And for rest of the relief, they'll
now,
go and establish their case before the trial court, my lord.
That definitely will the fact and situation see like that will be seen. But then the otherwise it will be totally.
In that case, if we can come to that conclusion, my lord.
Let them file an affidavit then, my lord, and produce the record also.
That why the records are necessary. That is my submission.
They are scared. If the record is open, then so many things will come out.
So many things will nothing will go beyond that.
Nothing will come out, my lord. We are not scared to produce.
No, if they produce once,
I'm trying to shorten the matter, my lord. Because ultimately that is the only relief they can get.
If you shorten it, this court will be very happy.
My lord, one part. If in case this issue is not decided, I'm just putting.
No. You see, if you do not have a grievance, why should we go on this?
No.
Once they withdraw that means go allegation against you.
No. What is my point of view is this, my lord, that if that relationship is not defined, my lord, properly, then in future also they will take the same clause and they will say that, you are a husband and wife, you cannot participate. They may not terminate the contract later on, but on the first stage they will stop me.
We are not in a PIL, see, Mr.
Not PIL, but
you will raise that issue when you are affected.
Competition Act takes care of that part, my lord.
There could have been some other kind of argument also, since you have not raised. This court is not giving you any hint on that. But then, you see, basically on that relationship. So anyway, since you see, like right now, if there is any willingness on the part of the respondents,
only may I state
withdraw,
my lord, blacklisting part I can persuade them, my lord. Criminal prosecution I go.
But that is okay. You do not have to do anything beyond that right now, my lord. The things which you are not willing to do, what is the question of court forcing you to do it? There is no question. There is nothing from the court. Even that blacklisting part, whether you should withdraw or not, that is up to you. It's nothing. Well, but then it's only a suggestion. You see, in such a case, our work may, you see, the difficulty in our work may come down. You see, like it will be reduced to some extent.
That is my endeavor, my lord. Rather than a need of passing a very elaborate judgment, well, we can shorten.
Because if there is a decision by you to scrap this project, there is no question of awarding same to him. Now only he can have a claim of damages. Damages for this court would be.
It is for the trial court to decide, my lord. That we agree, my lord, totally. But let him file an affidavit. So what he is ready to do.
There is sufficient indication from this court what Mr. Mujika does now.
For approaching for the damage also, my lord, that limitation has to be condoned, my lord. Otherwise, I'll be helpless. I'll be formless, my lord. That limitation has to be condoned by this honorable court only. For filing a suit, my lord.
What is the limitation for filing a suit?
There is still the limitation.
3 years for 3 years for normally for a money suit and all. Yes. Claim of damages.
I will examine that part, my lord.
Please verify.
Yeah.
If something is required by enactment, would it be proper for the lead court to say?
No, but my lord, then I will be formless. The trial court will say that.
We will see to that when that stage comes. Yes, let us see what they do.
Well, I'll place the records, my lord.
You will place the record along with your instruction if you have anything. When you will place it?
I can do it any day, my lord.
Tomorrow.
Except Friday, my lord. Friday I'll have some difficulty, my lord.
But tomorrow, my lord, will place.
Records with us.
You will have fresh set of instruction by tomorrow also. Especially with regard to that stigma and all.
That
will require some departmental exercise to be taken up.
Monday or Tuesday, my lord.
Well, heard learned counsel for the parties. It appears that production of related record by the respondent would be necessary for proper adjudication of the matter. Dr. Bojika, learned senior counsel, learned D. What is
DSG.
DSG.
Shall produce the record. This is matter after a week.
A date may be given, my lord, so it will be. You can also produce the date. Let it be on 26th, my lord.
I do not know. Will be 26th will be 26th. Okay. Well,
hello, guys.
Today is what date?
Today is Tuesday, my lord.
19th.
This side, my lord. That is October.
Okay.
Item number 12.
Your book, Mr. Day. Oh, yes. Mr. Day is there. Mr. Majika is also. Oh, no, this is also. Go to Mr. Day. Yes. So long matter or short matter? Oh, AG is there.
My lord.
Yes.
Yes.
Miller, I'll have to take your lordship through the background of the whole matter.
Yes.
It will take a little time. Not a very long matter, but it will take a little time.
Shall we start? You see, like, I'm just saying because
DB
looking
is
at
there.
the time.
DB is, your lordship will...
No, DB, second half DB is there and we see the second half.
It will take a little time.
I do not know because we'll hardly have 15 minutes before the break.
Well,
so it will not be possible to finish it in 15 minutes.
Doubtful. But as per your lordship's convenience, if it is taken up some other days,
not only in my, I do not know well. It would be convenient for the court.
Well,
Your lordship may have it. Yes, may have it on some other day, my lord. Your lordship may have it next week, my lord.
It's all right.
It's not
lordship.
Heard, Mr. Chakraborty. Senior counsel assisted by
East Long
for the petitioner. Also, Mr. Arun Kumar, Radical Advocate General appearing with our colony. Yes, wait for why the parties reach this matter after a week.
Obliged.
Obliged.
Item number 30.
Please, your lordship.
Yes.
This matter, my lord, we have challenged the actions of the...
You are municipal lord.
We are for municipal, my lord.
Yes.
The EPF, my lord. They have charged us exorbitant...
You have to tell me the basic of the law and then only you will go to
my lord.
Yes. Anyway, just tell me your things.
But what happened in this case is, my lord, we were required to make some certain contribution towards EPF for the welfare of the employees, my lord. Now, what happened...
That is a statutory requirement.
It's a statutory requirement. Now, over the period of time, my lord, what happened due to some financial constraints, my lord, we were not in a position, we were not able to pay, able to pay certain amounts on time. Now, be that as it may, what had happened actually here, my lord, is we had made certain payments towards the EPF contribution. My lord, what had happened is, it was done through, my lord, some website was required to be done online, my lord. We did that. The payment was made through online, my lord, and it was duly received by the other side, my lord, by the EPF organization. Now, what happened, my lord? Certainly, subsequently, my lord, it was transpired that the amount due to my lord, some swapping of account, instead of one account, it went to another account, but of the EPF only. EPF organization only, which they detected later on, my lord. Now, what happened is, since they later on detected, my lord, it was refunded to us. We put it back in the actual account. Now, what had happened, interestingly, my lord, at the time when the contribution was calculated or considered, my lord, what happened is, my lord, they overlooked this aspect that all this while, the money was not with us and the default, if any, was not intentional or deliberate. Now, my lord, at the time of calculating or even considering the EPF contribution, my lord, they imposed cost, interest and damages on a section, my lord, what is that section? Section, my lord, 14B and 7Q of the EPF Act. My lord, your lordship is aware that so far as the interest...
The court is not aware of anything, please.
so far as my lord, the interest and the damages is concerned, it is rather compensatory and not penal in nature, my lord. Here, apparently, my lord, it was not...
willful and deliberate.
Yes, and delay was not at all...
This is an accidental miss.
Accidental case, my lord. And for that, my lord, for that period, or for such an action, my lord, there was a levy of about 5 crore, my lord. The interest and the damages was imposed to the tune of 5 crore on us.
Now, before these damages are imposed, is there any provision of giving you an opportunity? No.
Yes.
Now, it was earlier, it was told. In fact, they were aware of this aspect.
No, not talking about their... Say, supposing before they decided, they impose.
There was a hearing. There was a.
They participated.
Yes.
There was a hearing, my lord,
There was hearing
but they
after-
said, my lord, nothing could be done in this regard because over the period of time they had already, my lord, debited certain
So
accounts.
this court is required to go into all those things.
Absolutely.
That is
They debited the entire amount from us, and we under duress, my lord, because the penal consequences were there if we do not pay on time. My lord, it was paid.
It is not duress. Why you say duress?
My lord, because there's a provision for arrest also. Because of that reason, my lord, it had to be paid. In fact, it was debited from our account, not through us, my lord, but by way of certain communication to the branch manager of the bank, concerned bank where I am
No,
holding.
but then if the fault does not lie with them, it is something accidental.
No,
Why not you
Lordship,
consider
it is,
it?
no, Lordship, it is actually, it so happened, Lordship, when we have given them the chance that you come for the hearing and subsequently, if like on the course of hearing, you give us whatever the amount is paid to, whatever the amount you have paid, and initially it is under 7Q, then 14B is drawn. So, Lordship, I'll take you to the 7Q section.
7Q.
It is sometimes it is they are deducting, Lordship. They are deducting from the employee's share, and they are not
depositing in time.
Depositing.
No, but then the
This can Lordship. We are Lordship. The
Thapa says
person
that-
is very much aware to deduct from the employee's share, and the employer is not depositing. So how can it be, Lordship, that they are
no,
not
that
aware?
is okay. But then he said deposit was made, but then to a
Deposit
different
is-
account.
Yes.
Depositing. I am coming to, Lordship. Kindly come to section 7Q, Lordship,
Of the act.
of the Act.
Funds and Machinery Solutions Act. Interest payable by the employer.
Yes, Lordship. Lordship, now it says the employer shall be liable to pay simple interest at the rate of 12% per annum or at such higher rate as may be specified in the scheme on any amount due from him under this act from the date on which the amount has become so due till the date of its actual payment.
Yes.
So, provided that the higher rate of interest specified in the scheme shall not exceed the lending rate of interest charged by any scheduled bank. So, now, Lordship, if we come to their petition, Lordship, it is petition page number 16, Lordship. Read petition page number 16.
Yes.
Yes. Now, if we come to 1/2011, page number 16, come to the challans, the columns,
21 to
Lordship. It is stated for January 2011.
Where is that? 2016 is 16 of the writ petition, isn't it?
Yes, Lordship.
No, this is not the one.
There are two petitions, Lordship. One is amended and one is not.
I think I'm looking at the wrong petition. Yes, 16.
Yes. Lordship, now.
Statement showing amount payable under section 7Q and 14B, isn't it?
Yes, Lordship.
Yes.
So now, Lordship, and in January 2011, Lordship, the payment due is 15/2/2011.
These dates are not visible here.
And they have paid in 76/2019, Lordship. From my petition also you can see.
It's all right, but then see, we should find it out from here. Not anyway. It's okay. The some part is visible, some part is not visible.
Just give my copy to some Lordship. I'll go see from here.
111, 511, 17. It's okay.
Yes.
More or less same. Just keep it. Just return to her. Anyway, yes.
So it is
First column 111.
Yes, Lordship. Now it is 15 to 2011. Lordship. They are paying under on 17/6/2019. Lordship. Subsequently, they have paid all, but on subsequent dates. So under section 7Q and 14B, we are means penal interest can be charged. Lordship. Now what 14B says, Lordship. According to the Act, Lordship, what 14B says, they have this is from 2011-19, so they have paid subsequently later.
Penalties. 14 is penalties.
14B, power to recover damage.
That is Act of 1952, isn't it? The Employees Provident Fund.
Yes.
14B.
Head
note is penalties. Is it?
14. Kindly come to 14B, Lordship. It's 14A, then 14AA.
1A.
Then 14A, then 14AA. 14AB, then 14B.
No, here.
14B.
How can this?
14 is penalties. Then
Yes.
14A.
It starts at 14.1. Then 14.1A. 1 capital A.
14A.
Offences by companies.
Offences by companies. 14B.
Then comes 14AA, my lord, in bold.
1 second. Just you are reading from Employees Provident Fund.
Miscellaneous Act.
And Miscellaneous Provisions Act 1952. Section 14.
14B.
Yes, 1 second. Yes, 14A by
14,
companies.
14B.
Yes. Then 14A, power to recover damages.
Yes. Power to recover damage.
Yes.
When an employer makes default in the payment of any contribution to the fund, the pension fund or the insurance fund, or in the transfer of accumulation required to be transferred by him under subsection 2 of section 15 or subsection 5 of section 17, or in payment of any charge payable under any other provision of this act, or of any scheme or insurance scheme, or under any of the condition specified under section 17, the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty such damages not exceeding the amount of arrears as may be specified in the scheme.
That speaks about your authority.
Yes.
That is okay. There is no dispute to it, I don't think.
Lordship, it's our authority to recover the damage.
Yes.
Now, what further, Lordship, in 7I, it lies appeal.
There is a provision of appeal.
There is a provision of appeal.
And they have not availed it.
They have not appealed.
Yes, then.
Consistently, my lord, this was not the stance taken by the respondent. In
No,
fact,
but then if it's
all
if it
this
is
while, my lord, when this matter was my lord, proceeding before the other court,
no,
they
but
have
then
been,
if there is a
they've been
provision,
seeking time, my lord, to recalibrate and give us a new figure, my lord. And all of a sudden, they are now coming up with this. Anyway, my lord, if there is an infraction of, my lord, there is a my lord, if prima facie the order on the face of it appears to be, my lord, invalid and
7.
illegal.
You said 7?
7I.
Appeal to tribunal.
Yes.
Appeal to tribunal.
Any person aggrieved by notification issued by the central government or an order passed by the central government or any authority under the provision to subsection 3 or subsection 4 of section 1 or section 3 or subsection 1 of section 7A or section 7B except an order rejecting an application for review referred to in subsection 5 thereof or section 7C or section 14B may prefer an appeal to tribunal against such notification or order. Every appeal under subsection 1 shall be filled in such form and manner within such time may be accompanied
So
by
your orders are under which section?
under appeal under section 7I.
7?
Seven.
No, there is appeal.
My order is under section 14B. We have passed
Yes.
order under
So
section.
it is appealable. That is
it's an
appealable.
appealable order under section 14B 7Q.
Yes,
so it's
Mr. Thapa.
appealable.
Why don't you file an appeal?
This provision.
And it seems there is no time limit also.
There is no time.
So you can prefer it anyway.
The only, my lord, if I'm not wrong, but at that point of time when writ petition was preferred, my lord, there was no tribunal. If I'm not wrong, my lord, I have to seek instruction on this.
You take instruction and just see whether it's a tribunal or not.
There is a tribunal, CJIT Guwahati.
I need to check on this, my lord. But my lord, like I said, my lord, all this while this plea was never taken. In fact, they had submitted before the court that they would recalibrate.
It's a legal plea. It can be taken anytime.
I understand, my lord. That's absolutely correct. But my lord, what at least some sort of fairness is required on their part also. My lord, otherwise, the court's precious time would not have been wasted. Could have been, my lord, sent to the tribunal right on the day one, my lord. This was never done. In fact, all this while they have been seeking, they have been praying before the court that they will recalibrate and we will look into the issue.
Where is that order? They will recalculate.
Right? Here it is written, my lord. My lord, may kindly see the order dated 1910. First, they sought time to produce record on place the relevant record before the court. Then they again sought time on 4/11.
1910, which year?
2022, my lord.
Yes.
Because the plea, my lord, the query raised by the Honorable Court was specific to para 16. To that extent, my lord, they sought time to produce record. And thereafter, my lord, again on 14/11/2022, my lord, based on the records, they sought time to file an additional affidavit.
Yes. Then in the what this additional affidavits? What
They filed, my lord, they filed an affidavit wherein, my lord, they admit to the fact that yes, there has been, my lord, the wrong debit of amount into the EPF account, and of course, my lord, it was discerned later on, and it was returned back to us, and we immediately made payment. So all this while the money was with them, not with me. So for a period where the money was lying with them, are they justified to even impose interest and damages on for the period where the money was not with us, rather was with them? That was the only issue, my lord. The court was bothered at that point of time.
This money was lying with them for
Yes,
the entire period of default, which
absolutely, my lord. My lord, I'll show you the.
not
my lord,
entire period
I'll
of
take
default,
you.
lordship.
I'll take your lordship to the communication made therein. It was in 2019.
No, but say, supposing if you say that money was transferred to a wrong account, there will be documents to show that, isn't it?
Yes, it is an admitted position, my lord, by way of their letter itself. I'll take your lordship to the additional affidavit.
We'll continue with this. Of course, we do not know how much time we'll have in the second half because there will be division bench.
Can we have it in some other day? In the meantime, I'll just.
If you agree on that, this court will have no objection.
You can have it sometime.
But then, if it is money was in your thing, why will it not be unfair on your part?
Lordship, we will be I'll take Lordship to the thing that how the money has come to our account and how it is.
No, did it remain with you for that entire period?
Not for entire period, Lordship. Not for entire period. Just for 2 to 3 months.
No.
It's in my affidavit I have reflected. It's not for entire period.
So
Lordship.
all this are disputed question. How this court will determine that?
Lordship, that is why Lordship it is.
On their own.
It will be fit case for appeal. Anyway, we'll hear on that. If we find that there is a difficulty on the part of this court to go on finding, then we'll direct them to the appeal.
Lordship.
No.
That is what I'm saying. When shall we have?
We'll show, my lord, that yes, they have admitted to what we are saying.
After 2 weeks.
As your lordship, please, my lord.
Lordship, after 2 weeks, Lordship. Okay, because Lordship, I will not be available from 27 to 29, Lordship.
So after 2 weeks?
Lordship.
Let's pray for the parties. List this matter after 2 weeks.
Lordship.
Your Lordship, on the question of whether vicarious liability will be there, will apply in a criminal proceeding. I got
Yes. Who is the petitioner?
Or we may have next week also, Your Lordship.
We'll have it after 2 weeks. Next week we'll have it.
After 2 weeks.
None appears for the petitioner. Mr. Andy Shulai, learned AG, is present along with Ms. Arkonli, learned government advocate. You're government advocate, no? Not senior government advocate.
No, madam. I'm government advocate.
Government advocate.
I am for the private.
Mr. Sheikh for appears for the right?
16, 17.
List this matter after 2 weeks.
16, 17, 18.
Okay. None appears for the petitioner, huh? It will be
offline.
19.
What? Yes, Mr. Kharmanlang, you are in 19.
No, Lordship. I was just assisting Madam Sheila and
What is the case about?
Lordship, I'm not aware. I don't have the brief here, Lordship. Lordship, if
None appears for the petitioner. Mr. Kharmanlang, learned additional senior government advocate, is present on behalf of the respondent. List this matter after 2 weeks.
20.